Everyone stand for the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Patty, would you call the roll, please?
Mayor Marino,
Here.
Vice Mayor Marciano.
Here.
Councilmember Woods.
Here, ma'am.
Councilmember Lane.
Here.
Councilmember Litt.
Thank you. We are here for one reason only, that's to discuss case number 50-2018-CA-001408-CAXX-MB, and we're here to discuss the appeal. So I will open the discussion. And Max?
Yes, ma'am. If I may, we received the order from Judge Curley this past Friday. He issued an order declaring in count one we prevailed with regard to the time of the election. They had filed for declaratory relief and a prayer for injunction, and that both of those requests in that count, or those prayers for relief in those counts, were denied. They were granted a declaratory judgment as it relates to count two, which is question number 1 of the ballot, where the court ruled that the ballot summary was legally insufficient. They prevailed in count 3, which is ballot question number 2 with regard to the term limits for the same reason. They were denied relief, and the city prevailed on counts 4 and 5, which again were prayers for declaratory judgment and injunctive relief. As it relates to ballot question 3 and 4, which is ordinance 28 and 29, which is related to the amount of time a council member must sit out before they run again, and changing the method of election from majority to plurality. They also were allowed at the hearing to make an oratinous amendment or a verbal amendment to their petition and add the count or the allegation of a violation of the single subject rule under the Florida Constitution in section 166.041. The provision under the Florida Constitution is inapplicable, but section 166.041 was applicable, but the court ruled against them on that added count. They also were denied their emergency petition for writ of mandamus, in which they included 6 additional counts, basically a rehash of the previous counts. And so the judge ordered petition for declaratory relief and injunctive relief and the writ of mandamus. They ordered to, he dismissed count 1 for lack of standing, so we prevailed on that. He denied the petition as it relates to counts 4, 5, and 6, and granted it as it relates to counts 2 and 3. To the extent that the court finds the ballot questions are invalid, but denied to the extent the petitioner requests injunctive relief. So and declared that any votes on ballot questions number 1 and number 2 shall be deemed void. In light of the court's ruling and review of the case law, my recommendation is that we do not appeal. Again, it's up to the council. I would recommend that we do not appeal. However, I am asking for the council's authorization to cross appeal should the other side appeal.
Mr. Lohman, are you telling us that the ballot language that you wrote is so defective that the city will lose if we
Hold on.
Not even time for discussion.
Hold on, Matthew. Let me recognize you before you pipe in. Okay, were you finished?
Yes, ma'am.
Matthew, would you like to be recognized?
Yeah, Mr. Lohman, are you telling us that the ballot language that you wrote is so defective that the city will lose if we appeal to the Court of Appeal? Are you admitting that you committed legal malpractice?
Oh, heavens.
I'm not even...
Don't respond.
Okay, then I'll make it a clear question. I'm going to make it a clear question. Are you telling us that the ballot language that you wrote is so defective that the city will lose if we appeal it to the Court of Appeal? Will we win or will we lose if we go to the Court of Appeal?
Well,
Mayor,
I would submit to you...
Hold on, Max. Mayor, we are here to discuss what is best for the city. We're not here to discuss the argument of language. Nobody in court is arguing what is best for the city. They're arguing language. And I think we need to go forward and give the city attorney direction on what we should do forward, not admit to something, or he shouldn't admit to something what is already in the past, what the judge has already signed.
My
We
question
need
is,
to
are
figure
we-
out what we're doing, what's best for the children, and what's best for the city.
Okay, my question is, we've got a recommendation here. And we need to know, if we go to the Court of Appeal, do you believe that we'll win?
Well, if I could predict victory conclusively, I would be the highest paid attorney in the United States of America. I don't know if you possess that ability to tell your clients conclusively that they will succeed on appeal, because there are numerous occasions where you, and this is a fact, and anybody that ever litigates knows that you can be 100% right, and the best you've got is a 50-50 chance. So my advice to you as the city attorney, to the city council, is that I believe the smartest thing to do is to accept the successful defense of ordinances 28 and 29, because I believe that if we appeal, the other side will almost certainly cross appeal, which then puts those two decisions in jeopardy. And as it relates to any other advice regarding the appeal, I'm not going to get any further into it, or the merits of our case, or whether or not I think we would prevail or not, in an open forum.
So my question is, people often ask me, they come to me and I make this assessment on a daily basis. Should I appeal? If I appeal, will I win? And so I'm asking you, for your advice as our attorney, what is your advice? Will we win?
All right, Matthew, hold on. Hold on, everyone. Our discussion right now is we are here to ask whether we want to appeal the ruling right now as it stands, which, if I'm not mistaken, we won 75% of the claims against us. Is that correct?
No, you want half
Okay,
the
be
claims.
quiet. I have the floor. We are here to decide if we are going to appeal this ruling. So, may I have a motion and a second?
Mayor, I'll motion to move on with this decision so we can get on with moving forward with this to not appeal.
May I have a second?
Authorizing the city attorney to cross.
And authorization for the city attorney to cross appeal if it needs be. But right now, I'm motioning to not give the city attorney authority to appeal.
May I ask a question? Madam Mayor,
Sure.
please define, I'm not an attorney and I'm not a lawyer and I don't ever really go to court, so I don't quite understand what it means to be authorized to cross appeal if there is an appeal from
If the petitioner or the plaintiff were to appeal portion of the ordinance, or the portion of the lawsuit that we prevailed on, if they appealed any of those portions, which would, in my opinion, would most likely be ordinances 28 and 29, not so much the first count, because they were already told they don't have standing. But be that as it may, they could appeal anything about which they didn't prevail. And if they did that, then I would request the authority to then appeal, cross appeal, which means we would then appeal on the two parts that we didn't prevail on.
And if you choose not to, or if the city chooses not to represent the appeal, then their appeal of whatever ordinances they wanted to, or whatever decisions they wanted.
We would just be defending against those again.
Okay.
We'd argue it in front of the fourth. It would get briefed to the Fourth District Court of Appeal.
Thank you.
So we are here again, Matthew, we are here again to decide whether we are going to appeal the decision we have in front of us at this moment. We have a motion. We need a second.
I will second.
Thank you. Is there additional discussion?
Yes, I'd have just additional discussion. We're trying to make a decision about whether or not we should appeal. So I would like to know from our attorney what the probabilities of success are on appeal. I need to know that in order to make the decision.
Matthew, that's enough.
Okay, you can make it without appropriate decision. Second, appropriate information. Second of all, my second question, Mr. Lohman, is plaintiffs and their counsel have already invested substantial time and money on this project on behalf of the city, and they're halfway there. What makes you think that they're not going to complete the job? What makes you think that they're going to leave this cake half-baked? I'd be very surprised, and I don't know what they're going to do, but I'd be very surprised if they didn't finish the job they started. So do you anticipate there will be a cross appeal?
I have no idea. I have no way of knowing what the other side is going to do. Moreover, I take issue with your characterization that they have spent substantial sums of money on behalf of the citizens of Palm Beach Gardens, which is frankly false. Mr. Dinerstein represents himself and his own issues and his own desires, not the city of Palm Beach Gardens. We were sued. We did not sue. And to characterize it as if the city went out and did something to try and be sued or to bring suit against someone else is patently false. And again, Mr. Dinerstein does not represent anyone but Mr. Dinerstein. He is not an elected official. He's not an appointed official. It wasn't Sid Dinerstein on behalf of the voters of Palm Beach Gardens versus the city of Palm Beach Gardens. It was Sid Dinerstein versus Susan Booker, the city of Palm Beach Gardens, and Patricia Snyder in her official capacity as the city clerk.
Well, as far as discussion is concerned, I'll conclude my opinion, and then we can vote. I believe that these ballot questions, as written, are perpetrating a fraud on the citizens of Palm Beach Gardens.
Matthew, you've said this
I'm going to finish
over
my
and over
statement.
again.
You may not like it, but I'm going to finish
No,
it.
I don't like how you are doing this.
Okay. I think the citizens of Palm Beach Gardens are exercising their constitutional right to vote, and they're going to the polls in good faith, and I believe that they're being misled by deceptive and misleading ballot language that makes the true meaning of what is being placed before them unclear. I want to warn the public. Section 4-1 of the current city charter states, quote, "No individual shall be elected to the office of council member for more than 2 consecutive full terms." The proposed ballot language eliminates the 2 consecutive term limitation and gives council members the right to return after sitting out for 3 years. And the ballot language doesn't let the voter know this. Instead, the ballot language is deceptively written so as to trick the voters into thinking that they're voting for term limits when they're actually abolishing the 2 consecutive term limitation that is currently in the charter. There's a fraud that's going on here, and we as council members shouldn't be parties to it. We need to be honest with our constituents, and we need to have this matter decided by the 4th DCA.
Thank you, Matthew. We noticed that you're an attorney, and at this point in time, you're a council member, not an attorney. Remember that when you are up here. You seem to forget that constantly. Be quiet.
At least I know what I'm doing.
May I?
Whoa, wait,
I have
wait,
to address
wait.
not that. I have to address what Councilmember Lane said with regard to the 2 consecutive terms and what's misleading the public. The court disagreed with Mr. Lane. Ordinance 28 was upheld, as was 29. So there is that issue as regards. As far as his pejorative remarks about me, I'm not going to even dignify them with comment.
Madam Mayor, may I make a comment, please?
Yes, you may.
Just to respond, but really just to clarify, we're here to decide if we want to appeal the decision. And we have a motion and a second to not appeal, meaning that questions 1 and 2 are not going to count in their vote. So the fact or the thought that we are actively trying to pursue a deceptive direction here is not true. We're here to decide. Now, the questions that we asked obviously didn't pass a judge's opinion, so we're here to decide whether or not we want to pursue it or not. And we're excuse me, I'm sorry. And we're not. We're not going to pursue it. So any thought of deceptiveness would have happened 6 months ago, not today. So to bring that back up is unnecessary. And you know, I've always tried to not use this dais as an opportunity to grandstand and to, you know, make comments that really are not necessary or even relevant to the discussion today. The whole point, though, Matthew, and I will refer this to you, and in all due respect as well, what we're trying to do and what we've tried to do, my opinion on this from day one, was to try to get clarification to make sure that our charter is unambiguous. Whether or not you agree or the residents of the city agree with the questions that are posed to them is one thing. Whether or not you think it's deceptive or other people think it's deceptive is another question. And I don't see, we've tried to be as upfront and open as possible with this process. So if we are choosing to not appeal, and the 2 questions that come on the ballot will be counted, questions 3 and 4, I'm hoping that we'll get some clarification to make sure that the charter is going to be spelled out in an unambiguous way, so no one can read the question in the future and say, well, I thought it meant this. Because whether you or anyone else likes it or not, there is now a true uncertainty as to how long people have to sit out. Now, you have your opinion, others have their opinion, and it is open for interpretation, whether you agree with it or not. And I think we have that pretty much decided, that there is some ambiguity in that language. So can we not try to find a way to clarify that so we can move forward, and then we can decide in the future how and if we want to try to revisit the questions that our Charter Review Committee put together at a different time. And that's really all we're trying to do here. I don't feel the need to, lambaste the city attorney because he put questions and language together that wasn't supported by a judge. I mean, that's where we're at here today. So I would like to make sure that we finish our business here today, and we consider at our next council meeting or through the next 12 months after the next election to see what the residents choose on questions 3 and 4, how if we want to proceed. And it's as simple as that. There's no other agenda that we should be carrying today.
That's correct.
Okay, I guess I'm going to respond briefly, Mark. I have tremendous respect for you, and I know you're a great leader up here. However, this ballot language, if it were truly and fairly written, as I recommended, what it would say is the current charter states that no individual shall be elected to the office of council member for more than 2 full consecutive terms. It would then clear up the fact that what's attempting here is to allow people to sit out 3 years and come back. It doesn't. The way it's written is to make it appear that people are voting for term limits. And I know this for a fact that it's unclear because our neighbors have even come to us and said, we don't understand this.
Matt, are we talking about the two that are on that
Yes,
are on?
Carl.
Okay, I just want to make sure.
I'm talking about number 3.
Okay.
People
right.
don't understand it. They think they don't know what they're voting for. It's poorly written. It's deceptively written. It's so easy to have done it correctly. You would just say, this is what it says. This is what we're proposing.
Thank
But
you,
we
Matt.
didn't. So that's my problem. It's an integrity issue.
Right now, we're here to discuss whether to appeal the decision on questions 1 and 2. We have a motion and a second. Where am I procedurally, Max, that I need to be?
Just the only thing that remains is to call the question, Madam Mayor.
Okay.
Is there any other Matthew, do you have any comment? I don't know if we want to.
No, I mean, I think that,
I think the discussion boils down to, as the 4 of us are here, we're not discussing questions 3 and 4. That is not what the appeal is for. The appeal is for questions 1 and 2. So the discussion on question 3 and 4 is really not a valid discussion at this point in time. We're here to discuss the appeal on questions 1 and 2, and as a 4-member panel, because we're only 4 today, decide whether we want to appeal the judge's ruling or not. Did I state that properly, Max?
Yes, ma'am.
Thank you.
And the motion did include the authority to cross appeal on 26 if
if our non-appeal is
appealed, correct.
Appealed.
petitioner chooses to appeal.
Correct.
okay. So, all those in favor of not appealing questions 1 and 2, and then appealing if there is a cross appeal, please vote yes.
Aye.
Yes.
Aye.
All those against?
Nay.
Motion carries 3-1. And at this time, I believe we are done. Meeting is adjourned.